I have what could fairly be described as a pretty serious food allergy. It's one I feel compelled to share with restaurant staff and friends that we visit with. It's deeply unfun, but the alternative is anaphylaxis, so it's worth it. The silver lining that I've been able to identify, though, is that it shows me how fiercely I'm loved by family and friends who generously announce to others at parties that they, too, are responsible for not murdering me. For my service member spouse, I am equally fiercely protective of what comes into our home. We live in a state where recreational marijuana use is legal, but it's still not legal for federal employees. So, when in doubt, we abstain. It's hardly a sacrifice, and with our efforts combined, I stay alive and my spouse stays employed. It's a real win-win. If he's to be believed, Navy Diver First Class Dillenburger could have really benefited from similar vigilance. This is Conduct Unbecoming. I'm Erin, and I'm your host. Logan Dillenburger joined the Navy in 2010 and worked his way up to E6 over the course of 12 years. As best I can tell, Dillenburger was stationed in Stuttgart, Germany in April of 2022. Dillenburger was single and ready to mingle and began dating a local German nurse who we'll call Clara. In a completely predictable course of events, he began sleeping over a few times each week. What was perhaps less predictable was that on August 21st, 2022, Dillenburger failed his routine urinalysis, testing above the threshold for cocaine. His test revealed a low level of cocaine metabolite, but cocaine metabolite nevertheless. In accordance with that positive test, he was ordered to return to the United States for his reckoning. He arrived in the U.S. on September 18th and took and failed another drug test the following day. Pursuant to those two drug test results, from tests taken approximately 1 month apart, Navy prosecutors at Naval Station Norfolk referred Dillenburger to special court-martial for 2 specifications of wrongful use of cocaine. As we discussed in episode 21, the Sullivan case, at times cocaine has valid medical applications and prescription. It wouldn't be wrongful consumption to consume it pursuant to a valid prescription. In that respect, it's like any other prescription drug, and like all those other prescription drugs, a drug test doesn't reveal how someone consumed cocaine, whether they knowingly ingested cocaine, or whether they wrongfully ingested that cocaine. Those sorts of findings require evidence beyond just a urinalysis result. It's pretty easy to look into whether someone received a valid prescription for a controlled substance, so it's kind of easy for a defendant to establish that drug use was lawful. It's a little harder for a defendant to prove that they ingested a controlled substance unknowingly. And I suppose there are also physical signs that could reveal easily whether someone is a habitual and long-term consumer of nose candy. Snorted cocaine, or cocaine consumed intranasally, can cause nasal congestion, damage to tissue inside the nasal passage, including inflammation, ulcers and erosion of the nasal septum, tooth and gum decay, tooth loss, oral lesions, loss of taste, and loss of smell. Prolonged usage has also been associated with an increased risk of oral cancer. But Dillenburger wasn't testing at high amounts, and his 2 positive drug tests over the course of his 12-year career wouldn't seem to suggest prolonged usage. Which is to say, none of these side effects were apparent problems in the prosecution of this case. So, there wasn't much evidence to suggest or narrow down how Dillenburger consumed cocaine. At his court-martial, a senior chemist from the Navy Drug Screening Laboratory testified that Dillenburger's urine samples both contained the cocaine metabolite. But, she said, the levels were low, and the test couldn't reveal whether Dillenburger would have even felt any effects from the cocaine he consumed. Although those levels were low, she testified that they were not consistent with a single use that showed up across the tests. The appellate opinion in this case indicates that the samples were taken 19 days apart, to which I only offer that August 21st and September 19th are not 19 days apart. Given that cocaine usually metabolizes and clears the urine within 4 days after consumption, Dillenburger had to be exposed twice. The expert hadn't personally tested Dillenburger's urine, but she did review the data that resulted when she offered her testimony at court-martial. When it came time for Dillenburger to mount his defense, Clara dialed in to testify. As a reminder, Clara was Dillenburger's love interest, the love interest who worked as a nurse in Stuttgart. More specifically, Clara survived the COVID-19 pandemic working as a hospital nurse. The hours were long and tense and full of challenging moments and difficult losses. She claimed she struggled to cope with the stress of her job and that in order to cope, or to keep up, she picked up the habit of mixing cocaine into her coffee. Clara said the practice was all the rage with her colleagues who apparently did not have access to Alani Nu. To make her cocaine coffee habit accessible and easy, Clara maintained 2 sugar bowls next to each other in her home. One held just sugar. The other held a sugar-cocaine blend. Clara left that hospital nurse job sometime before April 2022. But old habits and home decor die hard, and she did not dump out the cocaine sugar. She testified she actually forgot that there was cocaine in one of those 2 sugar bowls, and apparently 2 sugar bowls next to each other never dusted off the memory that one of them bore illicit drugs. Clara explained to the judge that when Dillenburger stayed over, he prepared coffee for himself. Because Clara forgot completely about the cocaine, she never explained that one bowl was sugar and one bowl was a one-way ticket to the clink. Clara also said she never saw Dillenburger put sugar in his coffee. I guess that could kind of make sense, both from the perspective of sparking the memory of the illicit substance and the perspective that I have, where I have literally never in my whole life seen a sailor or Marine add sugar or milk to their cup of joe. When Clara learned that Dillenburger tested positive for cocaine, she told his sister that she'd drugged his coffee. On cross-examination, Clara explained that wasn't true, that she'd said it because she wanted to make it clear that Dillenburger didn't consume the cocaine intentionally. Here's the question I personally get stuck on. When did Clara learn about the positive urinalysis test? Because if she learned about that August positive test, how did Dillenburger consume cocaine within 3 days before he returned to the United States, within 4 days of that September test? In the interest of balancing that thought, I'm aware that the lab tests take some time, and I'm aware that it's possible that Dillenburger's results came back and that he got yeeted stateside in rapid succession. But I've also waited for military flight ticketing, so I'm just a tiny bit skeptical. Dillenburger's testimony tracked Clara's. He said when he stayed over, he made coffee and used sugar from the bowl next to the coffee maker. His coffee didn't taste unusual, and he didn't feel differently after drinking it. He explained that he stayed at Clara's apartment the night before his flight to the United States and that he drank coffee at her place on the morning he left. Again, it's not made clear in the source materials whether he knew when he awoke that day that he would be flying back to the United States because he failed his urinalysis test. To bring it all together, Dillenburger testified that he never knowingly used cocaine. He also offered the testimony of his friends and colleagues as to his truthful character. Rather conveniently, the manual for courts-martial contains an example that negates the mens rea, the knowledge requirement of the wrongfulness of cocaine usage. The MCM clarifies that someone who possesses cocaine but believes it to be sugar is not guilty of wrongful possession of cocaine. Dillenburger offered a textbook defense that the military judge, sitting alone, rejected. The judge called Dillenburger's testimony fanciful and determined his version of innocent ingestion was implausible. Similarly, the judge found Clara biased and not credible. I'm sure he wondered how much cocaine Clara added to the forgotten bowl and how much sugar Dillenburger was using each visit over the course of months, how limitless this cocaine sweetener was. He had the benefit of hearing the testimony about the size of the sugar bowl in question and extrapolated that the testimony was sus. Use of a controlled substance may be inferred to be wrongful in the absence of evidence to the contrary. And sure, Dillenburger offered evidence to the contrary. His girlfriend testified that every cup of coffee at her apartment is a game of Colombian roulette. Dillenburger testified that he took his coffee with sugar from a suspicious bowl. But the judge was free to reject that testimony if it wasn't credible. With that background, the court-martial judge convicted Dillenburger of 2 specifications of wrongful use of a controlled substance and reduced him to E5. On appeal, Dillenburger challenged the factual and legal sufficiency of his conviction, as we would expect, and alleged a series of constitutional deprivations. He argued he did not receive due process of law, a violation of his Fifth Amendment rights. He also alleged that his Sixth Amendment right to confront his accuser was violated because the person who tested his pee wasn't the person who testified at trial. I think there's something to be said for taking an opportunity to review Dillenburger's due process claim, perhaps with a tiny bit more context than the Navy and Marine Corps Court of Criminal Appeals, given that due process is a trending term on search engines right now. During the court-martial, prosecutors urged the military judge to rely on a permissive inference. Use of a controlled substance may be inferred to be wrongful in the absence of evidence to the contrary. In effect, Dillenburger argued that because of the inference, a military judge would mechanically convict service members who tested positive for illicit substances. This, he argued, meant he and service members like him did not receive the benefit of due process. Due process comes up twice in the amendments to our Constitution. As relevant to our friend Dillenburger and others wrapped up in federal processes, the Fifth Amendment bars the federal government from depriving any person of life, liberty, or property without due process of law. That text does not distinguish between citizens and non-citizens. The 14th Amendment, ratified in the wake of the Civil War, incorporated that obligation to provide due process to the states. No state shall deprive any person of life, liberty, or property without due process of law, or deny to any person within its jurisdiction the equal protection of laws. I have one point to drill down on before we return to cocaine cowboy coffee, and that's what actually constitutes process. What do the 5th and 14th Amendments guarantee? I could say a lot about substantive due process, but I'm going to sidestep that today, and we'll focus on the promise of legality and a fair procedure. That's the hot topic these days. The text of the amendments mandate that the government provide fair procedures before depriving a person of life, liberty, or property. Cool. But what does that mean? In English common law, the basis for our system of laws, a state deprived someone of life, liberty, or property through criminal courts. Criminal actions required a fair trial, being informed of the legal action against you, and having an opportunity to present your side of the story, your defense. So if the federal government is going to deprive you of your life, your liberty, or your property, they owe you that same process that was established to protect the rights of criminal defendants. The federal government owes people notice of the potential deprivation. They owe people a fair hearing, and they owe people an opportunity to present evidence that might contradict the government's recitation of facts. Absent those three opportunities, it's hard to imagine the government provided due process or a fair hearing. There are limits to the offering, and if this sparks your interest, I did include a link to the discussion of Matthews v. Eldridge in the show notes. The test the Supreme Court established in that case weighs private interests against government interests and takes into account the risk the government erred or would err in its decision-making. I hope that brief detour provides a little more color, a little more context to Dillenburger's argument. Dillenburger argued that the permissive inference deprived him of his Fifth Amendment due process guarantee. Because remember, military courts-martial are federal criminal proceedings, so we're in Fifth Amendment land. Even when we zoom into the permissive inference instead of the court-martial as a whole, Dillenburger had notice, he had a fair trial, and he had an opportunity to present evidence, his side of the story. Dillenburger and Clara were the only people in a position to testify as to the wrongfulness of his ingestion. The failed drug tests don't have those details, they just reflect the concentration of cocaine metabolite in his pee. So the judge considered the extrinsic evidence that Dillenburger and Clara submitted as to whether Dillenburger knowingly and therefore wrongfully ingested cocaine. And the judge found the testimony about prominently placed but forgotten unlimited cocaine sugar bowls implausible. Dillenburger wasn't denied due process just because the judge didn't believe him. Each of us is entitled the opportunity to tell our side of the story, but that doesn't mean a fact finder must believe it. After the NMCCA resolved the Fifth Amendment concerns, they turned to Dillenburger's assertion of Sixth Amendment Confrontation Clause error. Dillenburger argued that he should have had the tech that processed his urine to cross-examine, not just some representative of the lab. In between his court-martial and his appeal, the United States Supreme Court decided Smith v. Arizona, holding a state could not introduce the testimonial out-of-court statements of a forensic analyst at trial unless that analyst is unavailable and the defendant had an earlier opportunity to cross-examine them. The expert in our case authenticated the 2 lab reports on Dillenburger's urine, offered as exhibits for the judge to consider in coming to a decision. Dillenburger argued this arrangement violated his rights as enumerated in Smith. At court-martial, though, Dillenburger never challenged the admission of the drug reports. He never even challenged the results of the drug reports. His defense focused on the innocence of his ingestion, not that he never ingested cocaine and that the lab reports were wrong. On appeal, Dillenburger even admitted in his reply brief that it wasn't significant whether the test results even contained any testimonial hearsay. Dillenburger couldn't knowingly waive his rights under Smith because Smith hadn't been decided yet, but he could forfeit his argument about the testimonial hearsay, and NMCCA concluded forfeit he did. Given that forfeiture, Dillenburger's failure to challenge the supposed testimonial hearsay below, the NMCCA had to evaluate whether admission of the expert's testimony was plain error. They had to determine whether they were convinced that any unconfronted testimonial hearsay was unimportant in light of other evidence. The NMCCA was convinced that any unconfronted testimonial hearsay was just a piece of the evidentiary puzzle, and that the rest of the case was strong enough to support the conviction. Further, any error was harmless beyond a reasonable doubt. So, with that and a small detour to confirm that it's constitutional to have a judge-alone court-martial, the NMCCA confirmed the conviction and judgment. Thank you for listening. If you enjoyed today's episode, please share it. I invite you to submit case suggestions and feedback to conductunbecomingpod@gmail.com or on conductunbecomingpod.com. Join me next time when we head back to Joint Base Lewis McChord for Double Trouble. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct Unbecoming is not approved, authorized, or endorsed by the Department of Defense.